Good afternoon, everyone. Welcome to the Legal Hour for February of 2026. My name is Elizabeth McCree, and we are here in February, and we are going to be discussing the litigation in the Benton Harbor water crisis cases. I want to make sure that that's clear right off the bat. There are several different cases that are currently pending in different areas of different courts. We're going to have a discussion about all of that today. But I am going to do a little bit of background understanding in regards to how the courts work. And then we will get into the different types of cases that have come from the water litigation. And then we will talk specifically about two recent cases that have come out of the federal courts. The first one being kind of a combined case, and you'll understand more about what I'm meaning in that in a few minutes, from all of the other cases coming together and potential settlement negotiations, and then the insurance issue that the city of Benton Harbor has initiated a lawsuit about against their insurance carrier to pay off the settlement that we'll be discussing. So we're going to kind of take that schedule of events for today. If you have questions, you should either be watching from my Facebook page for my law office or on YouTube. If you have questions and you're watching live, you can put your questions in the chat, and I might not be able to go through them right away, but just put them in there. I will make sure that I get to them before we get to the end of the discussion. But I may be able to stop in some of the meantime. There's a lot of stuff to go through, and I have an hour, so I want to make sure that I get through everything. And if you are not watching this live, if you're watching it on Facebook, you should be able to watch it for the next, I think, about 30 days. And then it will be on YouTube, on my law office YouTube page, and the videos stay there. So if you are looking for this and then you want to come back and look at it again and you don't find it on my Facebook page, you should be able to find it on my law office YouTube page. So I just want to give a little bit of, I guess, civil procedure primer for those of you who don't know a whole lot about how the courts work. We're going to talk today about federal court and state court. So in both federal court and state court, we have trial courts. Those are the lower level courts. So here in Benton Harbor, Michigan, our trial court is the Berrien County Court. And so in trial courts, that's where we hear evidence. That's where motions happen. That's where jury trials happen. That's where evidence takes place. That's where people raise their hand and swear to tell the truth and the whole truth. That's where depositions happen. That's where discovery happens and attorneys exchange information. That's where complaints are filed. The bulk of what happens in litigation happens in the trial court. So in this case, we're going to have the district court in the federal cases, and we're also going to have our Berrien County trial court. Berrien County has a combined district and circuit court, so we have a combined trial court, but that's where the evidence happens. That's where everything comes forward. The decisions that we're going to be looking at today come from the appellate courts. So in the federal system, you have the Sixth Circuit Court, and then you would have the United States Supreme Court. Those are the two appellate courts that would be relevant for the litigation in the Benton Harbor water crisis. In the state system, you would have the Michigan Court of Appeals, and we're going to talk a little bit about the Court of Claims, and then you would have the Michigan Supreme Court. So the Court of Claims is going to be another trial level court, put those with the trial levels. But when we talk about the Court of Appeals, or the circuit court in the federal cases, and then our Supreme Courts and the decisions from those courts, those are going to be appellate decisions. Appellate courts do not have people raising their hands and giving new evidence. They don't have a bunch of additional documents. Appellate courts look at what the trial court does. So they can't get anything new. They only review what happened in the lower courts. So you'll hear me say a couple of times that the appellate court has made a ruling, and then they sent it back to the trial court. So that's either going to be the federal district court or the Berrien County trial court, or the Court of Claims, and they're going to say, hey, this is how we ruled. This is what we think should happen. Now it's up to you in the trial courts to talk about what happens next. So it's important to have that understanding, and I'll go through it a couple more times as we go through. We have trial courts, but the decisions that we're going to be looking at today and the quotes and different things that I have for you are all from appellate courts. And appellate courts don't hear new evidence. They look at what the trial court has done and either said you did it right or you did it wrong, and here's what you need to do next. All right, so that's just a little civil procedure primer for those of you who don't have a background in how the legal landscape works. And so now we will jump into the decisions. Okay, the first line of cases in the Benton Harbor water litigation is what I call the Mitchell cases. So in this case, Mrs. Mitchell is the main plaintiff, and she is the guardian of a minor child. So all of the minor children that you're going to see throughout these cases are only notified by their initials. That's in order to give them some privacy as children. But each child is going to have a guardian, or what we call a next friend in litigation. So in the Mitchell cases, all of the plaintiffs are children. They're minors, from my understanding, from everything that I've read through. And they are represented by their parents, or guardians, or even potentially a lawyer guardian ad litem I've seen in a couple of cases. So in the Mitchell cases, we're talking about children who are going to be the plaintiffs. The plaintiffs are the people who file the lawsuit. And they filed a lawsuit against the city of Benton Harbor, against the mayor of Benton Harbor at the time that the incident took place, who is still the current mayor. Michael O'Malley was in charge of the water department, so he's listed individually as a defendant. Darwin Watson was the city manager. The city of Benton Harbor has a city manager system, so the city manager runs the day-to-day business. Miss Clark, I think it's Miss Clark, Mr. Oswald, and Mr. Sarcopato, I think also Mr. Onan, are state officials in different capacities through the state of Michigan. So we have Marcus Muhammad, Michael O'Malley, and Darwin Watson, who are city officials. And then the rest of those named individual defendants are state officials. And then you have the engineering company, which was assisting once they found the lead levels were high, and was assisting the city in what they should do and how to treat the lead levels. So the Mitchell plaintiffs have sued all of those people and entities as the collective defendants. Okay. This particular decision that we're looking at came out in May of last year, May of 2025, and this is from the federal courts. So this decision is from the United States Court of Appeals in the Sixth Circuit. The Sixth Circuit is Michigan, Indiana, Ohio, Illinois, I believe. So this is the circuit that would then go to the United States Supreme Court if somebody took it to the next appellate court. So this particular decision is the children, the Mitchell cases, against these particular defendants. So this is from the procedural background in the case. This case was first filed in the District Court of the Western District of Michigan. So again, that's the trial court for the federal system in the Western District of Michigan, and it was filed on May 27th of 2022. So the plaintiffs, Ms. Mitchell representing the minor child and all the other children that are involved, they had several claims. So first they said that the city and the city officials and the state defendants violated their 14th Amendment right to bodily integrity. That becomes important. That's the claim. So they're saying that the actions of the city officials and the state officials were a violation of these children's 14th Amendment right to bodily integrity. That is a federal claim. And also to be free from state-created danger. So those are two different claims under the 14th Amendment. The 14th Amendment to the U.S. Constitution gives everybody, all of us, children, adults, everyone, certain rights. We get equal protection of the law, and we get due process of law. So we all have a right to make sure that the state doesn't hurt us. So that's essentially what they're claiming in regards to their bodily integrity, in regards to drinking the lead water. And my understanding is that the plaintiffs in this case are all children who had high levels of lead after they were tested, who lived in the city of Benton Harbor. Second, the group of children represented by the guardians alleged that the engineering firms acted under color of law and violated those same rights. So that 14th Amendment right to bodily integrity and to be free from state-created danger. Now, color of law essentially means that this is another action of somebody from the state who is then taking action to hurt someone potentially under a violation of the 14th Amendment. So the engineering firm is not a state of Michigan employee or a state entity, but they were working to help a city and state entity clear up the issue. So the plaintiffs want to say that the defendant engineering company was acting as an agent of the state. They were acting under the color of the state, under the direction of the state, and the things that they did then impacted the bodily integrity of these children by drinking the lead water and having the high lead levels in their blood. Okay? The third set of claims is that the plaintiffs, the children, through their guardians, say there were state law claims of negligence and professional negligence against the engineering firms. That's important here. When you have these, what we call torts, you have intentional torts where somebody deliberately did something, lied, committed fraud that ended up hurting somebody, or you have negligence. They knew or should have known that the actions that they were taking could end up with a negative impact in this situation against the children who ended up with high lead levels. So sometimes people do something intentionally, sometimes people do something negligently, and that causes somebody to be harmed. So there were a bunch of different counts that the plaintiffs alleged in this lawsuit that involves the children who had high lead levels. And that was filed in federal court, in the trial court, in May of 2022. So in order to say that that 14th Amendment right to constitutional 14th Amendment protection against your body integrity not being infringed, you have to show that the actions of the government officials, so the state officials and the city officials, and then the engineering firms, as working for the state and the city in order to help the issues go through, that those actions that they took had to be constitutionally repugnant. So repugnant means like they have to just slap in the face of what a normal person put in the same situation would do, right? So a normal person acting as the city manager or the head of the water department or any of those other things, that the actions that they took during the time of the incident were constitutionally repugnant. They shock the conscience. So you hearing what somebody would have done in that position was so bad that it shocked you to the point that you would say they should be personally liable, and then there should also be liability on the part of the entity that they work for, in order for you to be able to get a settlement or get a judgment for a violation of that 14th Amendment right to bodily integrity. Merely being negligent does not shock the conscience. But unjustifiable and intentionally injurious conduct does. Okay? So that's important to know. This comes directly from this case where they're looking to say whether or not there's enough evidence to go forward to show that there could have been anybody in that group of defendants whose actions shocked the conscience. Okay? So what happened here is the lawsuit got filed by the plaintiffs. And once the lawsuit got filed by the plaintiffs, then the defendants do what is normal in civil cases. They filed motions to dismiss the case, saying that there was not enough evidence to show that any of the particular defendants could be found liable for this violation of body integrity and these violations of the 14th Amendment. This is routine. It happens in pretty much every civil litigation case. Each individual defendant, so the city, the individual people, the engineering firm, the state officials, all filed motions to essentially say, we should be kicked out of this. The case should be dismissed against us, me as an individual or the city or whatever the case may be, because there's not enough evidence to go forward. And so that's what the defendants did in this case. So the mayor, the city manager, the city, the state officials, the engineering firm all filed motions saying, hey, we should all be out of this case because we didn't do anything that shocks the conscience. Again, that's a normal course of action in a civil case. Many of them stated that part of the reason why they should not be charged is because they have immunity. Now, if you watched my show from last month when I talked about police officer immunity, you will know that that comes from Section 1983, which is federal legislation that talks about the fact that people who work for governments are under the color of law as an individual working for the government can say that I have immunity if I was acting through the course of my actions. And if I'm acting through the course of my actions as an employee or as a part of the government, then you have to use that reasonable person standard to say, were my actions reasonable? If they were reasonable, even if they were negligent, then I have immunity. So that's important to know. They file these motions to say, hey, kick my case at least out of this lawsuit because I have immunity. So the court is addressing that in this decision. The court is saying that qualified immunity shields a federal and a state official from money damages unless the plaintiff shows that the official violated a statutory or constitutional right. That's that 14th Amendment body integrity. I have a 14th Amendment equal protection right to body integrity, and that the right was clearly established at the time of the conduct. So that conduct would have been during the ongoing water crisis, the different things that were done to treat it, and then what was said to the people in regards to the situation. Remember, the plaintiffs in this case are all children who have tested with high lead levels after drinking the water and living in the community. Okay, so that second part of it is met. You know, they clearly had that right to body integrity at the time that all of this was going on during the period of time that Benton Harbor was dealing with the water crisis. And so the question is going to be whether or not the official violated that statutory right. If a defendant asserts qualified immunity at the motion to dismiss stage, that's where we're at. We haven't had a trial yet. I want you to kick me out already because I have immunity. I don't want to even be in this litigation anymore. So the defendant asserting that qualified immunity at that stage may argue both that the facts set out in the complaint do not show a violation of constitutional right and that the complainant has failed to state that claim. Again, the body integrity and the right to not be harmed by the government. Okay? And the appellate court, the Sixth Amendment Circuit Court, reviews the dismissal of the claim, what we call de novo. So they're looking at all the records. Remember, nobody is in the appellate court swearing an oath and introducing new testimony. You have to look at everything as it's already been presented in the trial court. And you notice here, you'll see, sometimes you'll see highlights because that's what I was doing to search Westlaw to find the cases. But they use, in this case, the precedent, the prior case of the Flint water cases. So they're using what they've already done in making rulings in the Flint water cases to make these rulings in the Benton Harbor water cases as well. So a municipality under Section 1983, again, 1980, the federal law that says, you know, if a state does something or municipality or anybody acting as a government official does something to somebody and violates their constitutional rights, they can be sued and the people can receive compensation because of that. So a municipality is liable under Section 1983 only if the challenge conduct occurs pursuant to a municipality's official policy, such that the municipality's promulgation or adoption of the policy can be said to have caused one of its employees to violate the plaintiff's constitutional rights. This is what we call the Monell Doctrine. So you'll see it's quoting the Monell case, Monell, and that comes from the United States Supreme Court. What does that mean? So that means that the policy is going to come from, for instance, the engineering firm telling the head of the water department and the city manager, treat the lead this way, do this, change this way that the water is going, stop the water in this home, test the water in these homes. So all of those different things that now come from the engineering company or any of the state officials saying this is what we need to do to treat or remediate the lead issue, those are all going to become policies that the municipality, the city of Benton Harbor, is using to address the issue. So because of that, if they could show that the people were taking these actions because there was a policy coming from the municipality to do so, then it is possible that they violated those plaintiffs, those children's constitutional rights. That's different than somebody just going and doing what they want to do. So if somebody just goes to the water plant and starts shutting off stuff because they think it's best and nobody has directed them to do so, then that would be their own intentional action. That wouldn't be under the official policy of the municipality. And that would be an intentional tort as opposed to doing something under the cover of your job. And if you're doing something outside the cover of what your job is, then you don't have that immunity. And that immunity would keep you from being liable for anything that happens. Quite honestly, whether it was negligent, even if it was potentially intentional. So in this case, in the Mitchell case from summer of 2025 in the federal courts, what the court decided to do was reverse part of the dismissal. So when people say at some point, the mayor and the city manager were in it and then they got kicked out, this is what they're talking about at that point. They were saying, no, this case should not be dismissed. We believe that the plaintiffs, the children, have pled a violation of the right to body integrity under the 14th Amendment against the city officials. So we're going to reverse the dismissal of this case and we're going to remand it. We're going to send it back to the trial court as to those city officials and as to the municipality, as to the city of Benton Harbor. But the state officials, they're out of it. They have not shown that the state officials did anything under color of law that would be an issue of violating these children's 14th Amendment rights. So essentially, they looked through everything that they had and they said, we can't point to anything any particular state official did that would have made it a violation of the 14th Amendment in any of the actions that they did in this case. But we think there is an issue that could be tried that the trier of fact could make in regards to the city officials and the city itself. So we're reversing this dismissal and we're reinstituting the lawsuit in federal trial court, in the federal district court, against the city officials. So that would be the mayor, the city manager, and the head of the water department at the time of the incident, as well as the city itself. Okay? So that's our first set of plaintiffs, the children who tested and had high lead levels. So right now, that case is pending in federal court against the city officials and the city. No state officials there in that situation. The state folks are out of it, but the city officials are still in that case pending in the federal court. Now, for those of you who are a little bit more knowledgeable about how the Court of Appeals and the federal courts work, there is another decision that came out in August of 2025, so a couple of months after this decision. In the circuit court, you go in front of a panel of judges. So there are, tons of circuit court judges because they have to hear everything in the 6th district with all those states that I talked about, Ohio, Michigan, Indiana, Illinois. They have to hear all those cases. But each of these cases goes to a 3-judge panel most of the time. Okay? So the decision that I just talked about came from a 3-judge panel. After that happened, the city officials and the others who remained in the case went and said, we want the full circuit court. We want all the judges in the 6th Circuit to rehear this case because we don't think you made the right decision in regards to whether or not we should have immunity. So we are making a petition for the full circuit court to hear this case before we take the next step, which would be to petition for the United States Supreme Court to hear the case. And what happened when they took it to the request of the full circuit court to hear it is the circuit court said, no, we're not going to hear it as a full group. But there were several judges of the United States Court of Appeals of the 6th Circuit who disagreed with that decision and wanted to hear it. And many of them in particular talked about in this decision that they did feel that particularly the actions of Mayor Muhammad were enough to come over and say that his actions were that egregious, that they were repugnant. Remember that language that we said. So they talked about the press conference that he gave and the other things of that nature. And they said, we don't have anything showing in particular with him that he did anything that would have been so shocking to shock the conscience in the actions that he took. So there were several judges of the Sixth Circuit Appellate Court that, in particular, when looking at the actions of Mayor Muhammad, would have thought that he should have qualified immunity. But that wasn't the ruling of the court, and they didn't hear it in bank. So keep that in mind, because potentially we have the settlement right now, but if for some reason the settlement doesn't work out, that issue could potentially be taken to the United States Supreme Court. So that's like civil procedure 2 for folks who may be in law school, but I want to put that in there for those who want to look at that particular opinion, because there's several dissents and concurrences by the judges of the appellate court that says we don't necessarily think the 3-judge panel got it right. So that case is still pending, and that involves the children who tested with high lead levels. Okay. So now we're going to head into the state courts. We were just talking about the federal courts. Now this decision is from the Michigan Court of Appeals. So this is that mid-level appellate court. We have the trial court, which is Berrien County trial court. And you see here it has Berrien Circuit Court as where this case came from. And then if somebody appeals, it gets appealed to the Court of Appeals for the state of Michigan, and then could potentially go to the Michigan Supreme Court. This decision was also from 2025. It was published in June of 2025. So around the same time as the Mitchell cases. I call these cases the Brazil cases. So you have the Mitchell cases, which is all children represented by guardians. And then you have the Brazil cases. And that includes also some children, some minors, but as well, it has some adults as well who are part of the plaintiff class in this case. So that group of plaintiffs is another class action of plaintiffs, but it includes both minors and adults. And they have sued, again, the city water department, 2 different engineering companies, Elkhorn and F&V, and the city of Benton Harbor. So they've sued these entities, the cities and the engineering companies, and then also Michael O'Malley in his individual capacity as a person who was in charge of the water plant. So this set of cases is in the state court, in the Berrien County Court, and the same thing that I just described happened. When the lawsuit first came in, the defendants all filed to dismiss the case. You don't have enough in order to take the case against me. So each of them as individual companies, as the city, and then as, their individual capacities filed to say, hey, kick me out of this lawsuit. I should not be here. Okay. So this action was filed in October of 2023, and they filed a class action lawsuit against Mr. O'Malley in particular, who was the director of the Benton Harbor Water Department at the time. And this case comes to the Court of Appeals specifically on an appeal from Mr. O'Malley in his function as director of the water department during the time that the incident took place. Okay. And there are 2 private corporations that were contracted by the city in order to address the issues of lead. Do this to remediate the lead, do this to test the homes, all of those different things. And the plaintiffs are alleging that they mismanaged the response to the discovery of the lead levels, and that they intentionally misled the public about the remediation of the water contamination. These are all the allegations. So just like we talked about 14th Amendment, federal claims for body integrity, these are the state claims in the state case. So they're saying that Mr. O'Malley in particular was grossly negligent, so not intentional, but negligent. And in support of the claim, they said that his inaction or ineffective action led to the high levels exceeding, and that people ingested that water. Okay? So we have our 14th Amendment, equal protection, due process, body integrity claims in federal court. Here, it's gross negligent and intentionally misleading the public in the state court. That's what they're alleging in state court with the Brazil group of plaintiffs. So Mr. O'Malley had went to the court, the trial court in Berrien County, and asked for a motion for summary disposition, kick me out. What happened was the Berrien County Trial Court granted motions for summary disposition with everybody else, but did not in regards to Mr. O'Malley. Okay, so he appealed this to the Court of Appeals. So he says, you erred in denying my motion for summary disposition and dismissing me from the action because I'm entitled to government immunity under state law. So we talk about government immunity under Section 1983 for federal law. There's also government immunity in the state under a state act. So he said that he had absolute or qualified immunity. And in this situation, the appellate court said, no, you don't. We disagree. And we affirmed the decision of the court to keep you in the case. And we send it back to the trial court for further proceedings, which means trial. So this case is currently pending in the state court in Berrien County. So we have federal litigation that's pending in the Mitchell cases, and we also have state litigation that's pending in the Brazil cases. But both sets of plaintiffs are in both different courts. There's cases all over the place that have been happening since these lawsuits started in 2022. Okay. But this particular case shows why there's still hearings going on and cases happening in the Berrien County Trial Court at this time. So Mr. O'Malley moved for summary disposition because of government immunity. And this is important. He cites the Benton Harbor Charter. That's the document that governs how the city of Benton Harbor is supposed to operate. And so he says that he should have absolute immunity because he was the highest appointed official at the level of government serving as the director of the Benton Harbor Water Department. He also believes, so that's absolute immunity. He also believes that he should have qualified immunity because the plaintiffs failed to allege that he had conduct that would have been grossly negligent. So remember, repugnant, gross, shocking the conscience. Like, people can be negligent. Most of us are probably negligent in one way or another every single day. But in order to be sued as an individual for your capacity in your job, it has to be gross negligence. It has to be repugnant. It has to shock the conscience. It has to go against the reasonable standard for anybody else who would have been in your position. And he also says that anything that he did was not the proximate cause of the plaintiff's injury. Proximate cause means because of what you did, but for you doing this, I would not have been hurt. So they're saying, but for you making a decision in the water department, I would not have drank that water and I would not have high levels of lead. You have to show that whatever the injury is to the person was caused by the actions of the person in which you're suing. So these are the things that he's saying. I should have absolute immunity because I was the highest appointed official based on the Benton Harbor Charter. As well, the plaintiffs didn't say anything that I specifically did that would have been so grossly negligent, that would have shocked everybody so much, that would have been against a reasonable person's standards so much that I should still be in this lawsuit. That's what he's arguing to the Michigan Court of Appeals. So the court affirms, as I said, they said, no, we think that there's enough here that it's a triable issue of fact, that it can go to the trial court in Berrien County and be in a trial. So they said at the end, moreover, the allegations in this case are not that defendants caused the lead to be present in the water system. Nobody is saying that, somebody went and, poured liquid lead into the, water plant and caused there to be lead because of some intentional action of wanting to poison people. The allegations are that after discovering the contamination, that Mr. O'Malley, specifically in his role as the director, exacerbated the water contamination by improperly treating for corrosion and making false and misleading statements to the public that assured that their drinking water was safe, all while knowing that dangerous levels of lead were present in the drinking water. If you accept that as true, because that's what the appellate court has to do at this stage. Hasn't been a trial yet. There's been some discovery. Documents have been passed back and forth. But remember, I talked about that de novo standard, the different standards the appellate courts have to use. In that situation, the appellate judges have to believe that what the plaintiffs are alleging are true when they're determining this. Okay? So if we believe that all of that is true, it is foreseeable that the harm that the plaintiffs cause, drinking water that had lead in it and testing and having high lead levels or having levels in their home, was the general kind of harm that this gentleman's conduct was negligently created by. Likewise, a reasonable juror, if the case went to trial, could conclude that he was the most immediate, efficient, and direct cause of the injury. They could conclude that. We don't know that because there hasn't been a trial. But what they're saying is we believe that it is possible that if this went to trial with the evidence that we have been provided so far, that somebody could make that determination. So there's still a question of fact for a jury or a judge to determine whether or not the director of the Benton Harbor water plant at the time that people were having lead in their homes and testing positive for lead was the proximate cause, but for his actions, these folks would not have been injured by having lead in their water and testing positive for lead. So those are two cases from 2025 that give us our two main groups of plaintiffs. Our Mitchell plaintiffs, which are all children who have tested positive for lead levels, and the Brazil group that includes both children and adults who had water in their homes and had evidence of water in their homes, regardless of whether or not they tested positive for lead levels. There is one other case, a group of folks that I want you to be aware of. And this case is an unpublished opinion that comes from the Court of Claims. So, what is the Court of Claims? The Court of Claims is a statewide, in the state of Michigan, limited jurisdiction court that hears and determines civil actions filed against the state of Michigan and its agencies. So this is a state court that specifically hears cases that are filed against the state of Michigan or engineering firms or other groups that, have claims against the state. There are Court of Appeals judges that sit on this court, and so they're acting as the trial court, but then you can also appeal to the Michigan Court of Appeals and the Michigan Supreme Court if you disagree. They hear cases involving highway defects, medical malpractice, contracts, constitutional claims, such as the body integrity that we talked about, prisoner litigation, tax-related suits, and other claims for money damages. And this court began in 2013. So there is also, or has been at some point, pending litigation involving the Benton Harbor water crisis in the Court of Claims. So as you can see here, we have our Brazil defendants. We also have our Mitchell defendants that were a part of this action. And then we have the Jansen Rogers group of plaintiffs. I'm sorry, I said defendants, they are plaintiffs. So we have our Brazil plaintiffs, our Mitchell plaintiffs, and we have our Jansen Rogers plaintiffs. From my understanding, that last group, the new group that I'm introducing into this mix are people who own businesses and had employees in the city of Benton Harbor. And that's an important part of it too. During this period of time that the crisis was happening, I had an office in the city of Benton Harbor. My first office that I had from 2015 until 2020 was in the downtown Benton Harbor area. And so, if I was making my lunch and washing dishes and everything else, it could have been that I was exposed to the potential of having lead water in the course and operation of my business. So they as well are filing to have how it has impacted their businesses because of the lead crisis. So we have three groups. The Mitchell group, children who tested positive for elevated levels of lead in their system. The Brazil group, which includes children and adults who had high levels of lead in their home, regardless of whether or not they actually tested for high levels of lead. And then you have business owners who operated their businesses or had employees in the city of Benton Harbor during the period of time. Okay? So that leads us to the settlement decision that came out last month, January 22nd of 2026. Now, there are cases still pending in trial courts. There's cases pending in the federal trial court. There's cases pending in the state trial court, right? But this has been going on for a long time. And part of what prompted my desire to address this and bring this forward to discuss what was going on is because we later I found it out sometime last year, earlier part of last year, that the insurance company was saying, we are not going to pay. A lot of that happened around the time of those first two cases that I talked to you about from the summer of 2025, where people in the city had been kicked out, but then they got put back in by the appellate court. And so essentially, from my understanding, what the insurance company is saying is if people did things intentionally or they were grossly negligent, then that falls outside of the scope of your insurance policy as a city. The insurance, all cities, all municipalities have insurance. Most entities have insurance. I have malpractice insurance for my law firm. The school where I teach has insurance if something happens. Like everybody has all these insurances to cover themselves. And the whole point of paying for insurance and keeping insurance is so that if you do get sued for something, and you as an individual or you as a city do not have the money to pay for it, you're supposed to pay that policy so that the policy pays it. People who have car insurance understand that that's how this all works. But there's been so much litigation back and forth in multiple different courts and the appellate courts and everything else with attorneys who are probably charging pretty high hourly rate for the defendants. Most of the plaintiffs, more than likely, have an agreement to get a portion of the settlement where they're not having to pay out of pocket for attorneys to represent them. But the individual defendants, the state, the cities, the individual actors within the cities, the engineering firms, all have to pay and hire lawyers. And most of them planned on at least paying for those lawyers through their insurance claims. That's why you usually, like, if you get work done at your house, you want people who are bonded and insured, because if something happens, you can get money from their insurance settlement. Okay. So since there has been discussion about that not being paid, and there have not been payouts for all of the attorney fees that have already happened, you have seen all this litigation going back and forth. Attorneys want to get paid. There have been settlement discussions. And settlement discussions, mediation, arbitration, all those kind of things happen very routinely in civil cases. So there has apparently been, at least on a preliminary basis, a $25 million settlement that has been discussed. Now, in order for that settlement to be accepted, it had to be presented to the federal court. Okay? So in this case, we see the Brazil defendants. So remember, the Brazil defendants in the case we just talked about from last summer were in state court, but now here they are in federal court. This is, and so they've been back and forth between federal court and state court. So that group, which includes children and adults, is here in the federal court in regards to this issue of the settlement. But as you also see, it also has the Mitchell plaintiffs as well. So those are the children who had high levels of lead. So both groups that I talked about in those two different cases from last summer are joined here together as a group of plaintiffs in a potential class action that are now coming forward to be able to say, hey, we have reached this settlement. Okay? So in this order, it says preliminarily, we are looking at this settlement order and we think it should be okay. We believe that it would be appropriate and that it properly identifies the class of people who should be able to get from this $25 million settlement some portion of financial damages. But it says, particularly down at the bottom area, and this is, I know it's small, but you'll be able to, if you can, make it bigger on your screens or whatever the case may be. All individuals who have resided in Benton Harbor for a period of 2 weeks or more from August of 2018 through November of 2021, excluding the individual Mitchell plaintiffs. What does that mean? So potentially anyone who resided in the city of Benton Harbor, not Benton Township, in the city of Benton Harbor for 2 weeks from August of 2018 through November 2021 is potentially eligible for the settlement unless you are an individual plaintiff in the Mitchell group. The Mitchell group are the kids who tested with high levels of lead. So the reason that's separate is because there are probably additional things that are going to be a part of the settlement for those children who tested with high lead levels. But if you are somebody who rented an apartment, to be quite honest, if you stayed for the summer for 2 weeks and you had an Airbnb in the city limits of Benton Harbor between 2018 and 2021, then you would be eligible as somebody who resided in the city of Benton Harbor to be a part of this settlement. I'm going to go through a couple of other things that are particular in this settlement document. Because this settlement involves injunctive relief and an assignment only, at this stage, the court need not consider the distribution of proceeds. This is just step one, guys. This is just whether or not you fall into the class. You're going to have to show that you resided for 2 weeks between 2018 and 2021 in the city limits of Benton Harbor. So if you were living with your cousin or you were living at your grandmother's house and you don't have a lease that has your name on it, you better find a bill. Your phone bill has that address on it, something you need to be able to show. If you don't have a deed or a lease that you lived in the city of Benton Harbor for at least 2 weeks, you need to show something that shows that you resided there to become a part of the class. Because right now there's no money to get because everybody's trying to get the money from the insurance company. But you still need to do what you need to do in order to qualify as part of the class. If you are a child that tested with the lead levels, then you could be part of the Mitchell settlement, and that's going to be something different. So you could qualify potentially for both. But you have to figure out which one you go with right now. There are already plaintiffs who are in the Mitchell group, but there maybe are potentially people who had children who are now just testing for lead because something was going on and now they're trying to figure it out. And now, they might not even live here anymore, but they lived here during that time and now they're testing for lead. You could then potentially become part of the Mitchell group. As the settlement indicates, should plaintiffs and individual Mitchell plaintiffs prevail in the pending judgment against the insurance company and succeed in getting money for the class, and for the attorneys for the class, and for the individual plaintiffs, they will jointly submit a distribution plan. So then they will talk about how the money is going to be distributed. Right now, it's just becoming part of the class. And then for anybody who was a minor or has other issues where they need a next of friend or a guardian ad litem to represent them, all of those folks are going to be appointed and have people to be able to set and make sure that their rights are protected. Then they can file a motion for attorney's fees and costs and who's in the class and amend the structure and discuss how people are going to get paid. Okay, so this is just step one. Do you fall within that group between 2018 and 2021 that resided for at least 2 weeks, and can you prove it? So if you need to go start gathering those documents, you need to do those. The court must consider whether the proposal treats class members equitably. Again, this is just phase one. They say it multiple times in this decision. So no class members right now are being treated any differently. They're still trying to figure out who all is within the class. The relief is going to be available to anybody who is a member of the class. And that $25 million settlement is going to be applied to everybody once the attorneys and everybody else gets paid through that final distribution. So they also have a plan of sending a direct mailing to all the addresses in Benton Harbor. And now this is important because a lot of us know there are houses that have been knocked down, condemned, no longer exist since 2018. Not going to get mailings. So those folks that lived in those houses between 2018 and 2021 are different. If it goes to the house and there's somebody new that's renting and living there, it might not be the people who there might have been several people who rented that house between 2018 or 2021. So you might not get a mailing. That doesn't mean that you don't qualify. You could live outside of Benton Harbor now. You could be in Indianapolis or Texas or somewhere else. But if you live there for 2 weeks and you can prove it, you're still a part of the class. There also is supposed to be a paid media campaign that explains to people how they are a part of the class. But I'm telling you right now, if you think that you're part of the class, you need to start gathering your evidence to prove a lease, a bill, something to be able to show that has your name on it to say that you should be eligible as a member of the class of somebody who lived in this area for at least 2 weeks between 2018 and 2021 in the city limits of Benton Harbor. And again, those who are minors or those who are otherwise legally incapacitated are considered incompetent, are going to have people appointed to help represent their claims. And this is something that I have personal experience with because during the Flint litigation, I represent foster children. And I had two sets of sibling groups who had been placed, at least for a period of time, in the limits of Flint that were affected by their water crisis. And so, in both of those cases, the parents' rights were terminated. So, while we were waiting for the adoption to take place, I got letters saying I needed to become the next of friend. So, like in the Mitchell cases, serve as the guardian for my clients who were part of that class. And then, after they were adopted, their adoptive parents became their next of friend. So for a while, I was a part of the Flint lawsuit, and that lawsuit had a lot of different things. The settlement in that case provided for additional supports for these children as they go throughout school and for the rest of their life. Medical appointments and medical things being covered for them because of the fact they had high levels of lead in their system. And that's part of the reason why I think that the Mitchell case, why those individuals are in a separate category than everybody else who may potentially fall into the group as somebody who resided for 2 weeks. Because once somebody does have high levels of lead and tests in their system, it impacts them for the rest of their life. And so there's going to be settlement negotiations to talk about what happened to those folks, and what needs to be done in order to make sure that they are cared for and that their issues are addressed because of the lead that was found in their body. So that's why I believe they're in a separate class. And then we have the decision that came out on January the 9th that talks about the lawsuit that was filed by the city of Benton Harbor against Travelers Insurance Company. So this is the insurance provider that they had been paying and that they expected to be able to pay the attorney's fees through all of this litigation that we have just talked about over the course of this almost hour. And so they filed this lawsuit in the Berrien County Trial Court. They filed it in state court. And one thing that you can do is, if there are claims that are federal in nature, whoever the defendant is can ask that the case be removed from state court to federal court, which Travelers Insurance Company did. So they moved their case from the Berrien County Trial Court to the federal district court. And so, at least as of right now, I believe the city of Benton Harbor wanted to put it back into the Berrien County Trial Court, but that fight is going on right now. So there's still ongoing litigation. And that ongoing litigation is going to determine where the money comes from. Because what we do know is that the city of Benton Harbor doesn't have the money. So they have to get the insurance company to pay. And that's why the prior order that I showed you from all the groups of plaintiffs coming together for the settlement is dependent on whether or not the city of Benton Harbor can win their case against the insurance company. So they will go through all the rounds of litigation, dismissal requests, and everything else. Maybe they will settle early, but maybe they won't. This might take a long time in order to figure out where the money is coming from. But in the meantime, if you are going to qualify for the class, you need to get started on seeing whether or not you qualify for the class of people that have resided in Benton Harbor for at least 2 weeks from 2018 to 2021. But this is far from over, in the sense that we have to find the money in order to pay the settlement. And that money is not going to come from the taxpayers or from all the other income that comes into the city one way or another. But in the meantime, the attorney's offices that have represented the individuals and all the other folks connected with the city are still wanting money. So that is one of the things that is currently going back and forth within the city itself when they're looking to move the money around, because right now they're just trying to play the lawyers to keep up the fight to be able to get the $25 million to have the settlement. So that was a lot, and I understand that. Like I said, this will be saved on my Facebook page for, I think, at least 30 days, and then it will always be on my YouTube page if you want to go back to it or have any questions. I put the actual front part of all of those opinions available for you, because if you put in the names of the cases or you put in the numbers, you should be able to also pull the copies. Those of you who know how to get in contact with me, you can send me messages through Facebook or email or whatever the case may be. If you actually want me to send you the decisions themselves, I can email PDF copies to you if you are like me and want to read through that in-bank decision where all the justices are fighting with each other. So there's a lot of different things that could be available for you to be able to read and understand. But the biggest thing right now is for people who believe that they're part of the class, that they lived in Benton Harbor for at least 2 weeks, resided in Benton Harbor for at least 2 weeks between 2018 and 2021 in the city limits, not in the township, and you believe you're a part of the class, you need to start getting your proof to be able to show it. Like I said, it's not going to happen quickly. I don't think there's going to be any settlement funds distributed by the end of this year. I think it's going to take a while, but you still need to gather, if you believe that you are part of the class, to be able to go forward. And if you are part of potentially having a child who did test for the levels and you could be part of the Mitchell group, then you need to be able to gather your evidence to be able to show that too. Let me see if I've got any. Hi, Rodney. I see you. Thank you. If there are any questions, please let me know. But those of you who know, I always start getting hoarse at the end and need to drink water. So we've made it an hour. It took me, to condense that in an hour, I think is a pretty good feat on my part. So I want to thank everybody that's been watching. Again, if you do have questions, you can put questions into the chat on these videos, and I will try to make sure that I'm going back and answering the questions the best that I can. But this is a lot of litigation. This has been a long time. And there are people who have been impacted by this. The decision of whether or not there are people who are responsible for violations of 14th Amendment body integrity and if there was gross negligence, that hasn't been decided at all. We haven't had any trials yet. The settlement would end that litigation. But in order to do that, then the city is going to have to be able to get the money from the insurance company. So keep looking at what's going on, keep figuring out, whether or not you're a part of the class, keep following it. But most importantly, keep supporting the people who have been impacted by this crisis. I did an interview earlier with ABC 57, and one of the reasons I said that I did this, because I'm not connected to any of this litigation or lawsuits in any way, is because I don't want this to happen again. It's happened in Flint. It's happened here. And to be quite honest, the Benton Harbor lead levels were higher than the levels that they found in Flint. I don't know if a lot of people know that. But, I'm from Benton Harbor. I care about folks. I've seen the results of children who have high levels of lead and how it impacts them for the rest of their lives. And the elderly who have high levels of lead in their system. We don't want this to happen to another community. We don't want anybody else to go through this. We don't want anybody else to feel, to be quite honest, the discriminatory impact of what is happening. And that's just the facts of the matter. So if anything, educate yourself about what's going on here so that we can prevent it from happening for another community and prevent any other child from unnecessarily being poisoned by lead. We don't want that to happen. So again, if you have any questions, go ahead and put them in the chat, and I will try to get back to them and review them and see them. If there's no other questions, let me take one more look at my chat. Thank you. I tried to be thorough and put it in layman's terms. Hopefully I did okay with that. And people's questions have been answered. That's a great thing to hear. All right. So I hope everybody enjoys the rest of their afternoon. For us around here with the snow, I know some of you all, if you're watching from the East Coast, or have a bomb cyclone coming. So stay safe and stay warm. I will be back next month on the 22nd. So I won't be doing the last Sunday of the month. I'll be doing March 22nd. I haven't picked my, if you have any ideas about what my topic should be for next, let me know. And this is Elizabeth McCree. I'm signing off for the